Hello viewers, welcome to our YouTube channel. Don't forget to like and comment. I'm Miss Mdombozi. With me here are my colleagues, Panashe Makumboti, Sini Muguto, Lili Malumisa, Felicitas Sinamo, and Kudzai Chakoma. We are Great Zimbabwe University students at Hebe Shitepo Law School, currently in second year semester 1. We are going to take you through constitutional contract law with Mr. N.K. MAPHOSA as our supervisor. This presentation will elaborate the view of the application and impact of the Constitution in contractual agreements, amongst other things. Allow me, ladies and gentlemen, to define to you what a contract is. A contract is an agreement which is entered into by two or more persons with the intention of creating a legal obligation. A contract requires animus contrahendi on the parties of the contractants. It is important to note that animus contrahendi simply means that serious intention. Constitutional contract law relates to the application of constitutional provisions in private contractual agreements. In other words, it governs the legitimacy of the contracts. Modern contract law is fundamentally a creature of the 19th century. It is also important to note that contract law is a modernized version of the Roman Dutch laws. Contract law provides a legal framework within which persons can transact businesses and exchange resources, secure in the knowledge that the law will uphold their agreement and necessary to enforce them. Roman Dutch law only partly recognized the principle of consensuality, but never went as far as extending it to all contracts as a general basis of the binding of contractual obligation. As I have mentioned earlier, our Zimbabwean contract law is a modernized version of Roman Dutch law, Roman Dutch contract law, taking into consideration the advent of the Lancaster House Conference, the 2013 Zimbabwean Constitution, Contractual Penalties Act, Consumer Protection Act, Labor Act, to mention just a few. Section 2 of the Zimbabwean Constitution points out that the Constitution is the supreme law of Zimbabwe. And I'm now handing over the discussion to Lili Malumi.
Thank you. I will look at the impact of the Constitution on contractual relations. So when we are talking about the impact of the Constitution on contractual relations, we are actually trying to measure the extent of the applicability of the Constitution that is either positive or negative. So I will first introduce the Supremacy Clause of the Constitution of Zimbabwe, Amendment number 20 of 2013, which actually outlines that the Constitution is the supreme law of the land, and any law, any practice, any custom, or any conduct inconsistent with it is invalid to the extent of its inconsistency. I will put a red light where it actually outlines that any law, any practice, or any conduct inconsistent with it is invalid to the extent of its inconsistency. This actually tries to outline that any private legal terms or provisions that are being provided in contracts, they are to bow down before the Constitution and give recognition to the constitutional values. I will move on where the Constitution applies horizontally or vertically. I will first look at section 42.2 of the Bill of Rights, which apply horizontally, meaning that obligations arising out of contract or private legal arrangement must not infringe on the rights of individuals. And again, on section 8.1, 8.2, 8.3, and 39.2 of the South African Constitution provides that a court, a tribunal, or a forum when interpreting the Bill of Rights itself must promote the values that underlie an open and democratic society based upon human dignity and equality. This actually outlines that the courts, they must strike a balance between the regulations of which, on the other hand, it serves as a basis upon which the concept of freedom and autonomy can be concretized by, and on the other hand, it can operate to limit the scope of the contractual freedom and autonomy. So the vertical application mirrors the idea that states must not infringe on the rights, on the fundamental rights of individuals. The horizontal application, again, it further actually raises the issue of whether or not the fundamental rights of individuals ought to be applied directly or indirectly to private agreements. In the case of Bharkuizen versus Napier, it highlighted that the direct horizontal application of human rights, which applies that parties could, as a matter of rights, invoke provisions contained in the Bill of Rights to establish or defend a claim. An indirect horizontal application of rights implies that a party must prove that a term of a contract violates a constitutional right, that a contract or a provision in a contract is contrary to public policy or illegal under the rules of common law. So this actually outlines a lot of haggle and conflicts in the competing values of private law and public law, alluding to a lot of conflicts that actually arises, unfairness and justice is to be sought every time. So I will actually leave this discussion to Sydney Muguto to take it further.
Thank you, prospective counsel. I'm going to shed more light on the competing values in constitutional contract law. Before getting into detail on the principles we purport to discuss here, which either run hand in hand or otherwise ultra various with the constitutional provision, I would like for you to take note that it is always imperative to reiterate the relevant sections of the respective constitutions, the sections which have already been introduced to you by my predecessor here, Lili Malumisa. So we have got what we call freedom of contract. Freedom of contract as such is not expressly listed in the Bill of Rights in South Africa or in the Declaration of Rights, which is chapter 4 of the Zimbabwean Constitution. Actually support the hierarchical argument that it is necessarily subordinate to any listed right which it may conflict with. Freedom of contract is not an expression of self-governance, of the basic values of self-governance and autonomy per se, but it forms the direct basis of such rights. So in essence, it gives a concrete foundation which in forms the basis of private interest of private interest depending on the circumstances. In the case of Brisky versus Drosky, it is mentioned that the principle of freedom of contract in itself is a fundamental constitutional value. It is always important to determine the principle of freedom of contract, which can actually undermine the extent to which a party is compelled to contract. You can also search on the case of Hoffmain versus South African Airways. I'm not going to talk about that. We've got also what we call privity of contract, or in Latin, that privitas. This doctrine, according to a book by Innocent Maja, means that a person who is not a party to a contractual agreement is not able to claim on such an agreement. What are we saying? Let's say we have two contractants, which are A and B. So C, being a third party to this agreement, cannot be able to claim on such an agreement. But in the case of this Napier versus Bharkuizen case, the judge reiterated that the constitutional court or any court of law can be given such powers to interfere in such a contract only to the extent that it regulates the excessiveness of the practice of such rights. We've got what we call pacta sunt servanda doctrine. This is a common law doctrine of pacta sunt servanda, which in English simply translates to contracts entered into freely must be enforced. The constitutionalization of such a principle is evident in both the South African and the Zimbabwean constitutions. They both uphold contractual freedom. One can easily note that the pacta sunt servanda actually encourages contractual freedom, which in turn is deeply rooted in the values of public policy. And public policy is the cornerstone of good values and the spirit of the Constitution. In the case of this Bharkuizen case, which was presided over in 2007, the judge of the Constitutional Court mentioned that, and I quote, "I do not understand the Supreme Court of Appeal as suggesting that the principle of contract, pacta sunt servanda, is a sacred cow that should be allowed to trump all other considerations." This only means that in as much as the courts would like to consider this principle, it can only be enforced hand in hand with the constitutional provisions. Allow me to pass this discussion to my fellow prospective advocate, Kudzai Chakoma.
Thank you, Counsel. So I'm going to take you through contracts that undermine fundamental constitutional rights. To begin with, it is important to note that fundamental rights in the Constitution are the major source of our public policy. The relationship that exists between fundamental rights and contract law can take the form of subordination from contract law to fundamental rights. However, it should be kept in mind that these rights, which are listed, can be limited if they are being guided by the provisions of the Constitution. For instance, the South African Constitution, Section 36, and the Zimbabwean Constitution, Amendment number 20, Section 86, subsection 2, which states that the fundamental rights and freedoms set out in this chapter can be limited only in terms of the law of general application and to the extent that the limitation is fair, reasonable, necessary, and justifiable. In a democratic society with equality, freedom, human dignity, and also justice. Therefore, it can be argued that infringement of rights and contracts can be seen as illegal, and this leaves our courts with the duty of creating a balance between the freedom of contract and also the infringement of rights. And in order for them to determine this, there are two tests which they have to use. And the first one is to determine whether the clause is reasonable and fair. And the second one is to determine whether the enforcement of the clause is reasonable and fair in the surrounding circumstances. And these are explained well in the case of Bharkuizen versus Napier. Moving on, it is also important to try to look into the rights that can be infringed in contracts. For instance, equality and discrimination. I refer you all to look at the case of Hoffmain versus SA Airways, where the other party was denied the employment because of his HIV status, and the courts compelled the company to offer him a job at their company. And we can also look into the Bharkuizen versus Napier case, where the time bar clause limited the insurance constitutional right, and the affirmations test were applied in order to determine if it was reasonable and justifiable. And the courts also distinguished between two possible scenarios where constitutional considerations may render contract terms which are contrary to the public policy. The first one is if contracts that undermine constitutional values of freedom, dignity, and equality. And I refer you all to the case of Brisky versus Drosky, where there was the issue of inequality and bargaining of powers. And the second one is contracts that undermine constitutional rights listed in the Bill of Rights. So I'm not going to go much into this, but it is important for you to all know that while contract law must respect the values enshrined in the Constitution, which are the fundamental rights, it is contract law which determines and which allows to what extent these rights are infringed and accommodated within it. The contract law values which are not protected by the Constitution or the fundamental rights listed in the Constitution therefore retain considerable importance when confronted with constitutional values. At this point, I think I should leave the platform for Advocate Bhana to continue.
Thank you for the opportunity. So I would like to talk on the validation of contracts in relation to the Constitution of Zimbabwe, and as well as discuss penalty stipulation in relation to the breach of contract. So first and foremost, I would like to talk of contractual capacity. So contractual capacity is very important in the law of contract, as it is one of the most requirements needed to validate a contract. So who cannot enter into a contract? Minors under the age of 7 have no contractual capacity at all, not even for contracts benefiting them. And we can trace this from the case of Kategori versus Muchabayo, which is one of the most in Zimbabwe, in as much as local standard. Sorry for that. So in this case, it conferred majority status any person who had attained the age of 18 as stipulated in the Legal Age of Majority Act. And according to Maja, any natural person who had attained or who has the age of 18 has a contractual obligation to do. So the Constitution of Zimbabwe, therefore, at section 81, confers that every child under the age of 18 years has the right to be protected from economic and sexual exploitation, from child labor, and from any maltreatment that may occur. Therefore, our Constitution concludes and apprehend contractual capacity in contractual relation. So secondly, I would like to talk and give a commentary on section 75 of our Labor Act of Zimbabwe. So it gave obligation to negotiate in good faith, which is a very good fundamental right given to our workers in Zimbabwe. So the three clauses in section 75 from A to C consider the elements of absolute good faith. So it's important to note that to fail to negotiate in absolute good faith will be construed as an unfair labor practice. And the principle of good faith is very fundamental. So I'd also like to talk of the penalty stipulations in line with the breach of contracts. So this penalty stipulation is back and emanated from the Roman Dutch law time, whereby the courts during that time, they had to apprehend and deal with absolute measures to deal with those persons who had breached certain contracts. So the English law, as time commenced, also adopted the same situation. And in 1992, the Contractual Penalties Act of Zimbabwe was stipulated. So I think, guys, we have a synopsis of what can happen. So thank you, guys. I think it's time to leave it to Advocate Felicitas.
Yes, we want to continue as just a conclusion. My colleagues herein have presented a number of issues now that expose the implication of the Constitution to contract law. On one hand, the Constitution seemingly vitiates the ambit of contract law. But on the other hand, we are seeing that the Constitution is actually the enabler that enables contract law to operate, because the Constitution is coming in to delimit even the interference of other branches of law so that contract law can have space to operate. But it is now not operating as it were, because the Constitution is bringing in such things as some peremptory norms that we have seen it discussed by my colleagues. You will find that in section 44 of the Constitution of Zimbabwe, where the Constitution indicates with a must, which shows that it's a peremptory norm that no one can go against. When the Constitution says natural and juristic persons must do that, it means even the contract law is supposed to subordinate now to the dictates of the Constitution. Then we have also seen, yes, closely related to the peremptory norms is the issue of constitutional supremacy that is emphasized in the Zimbabwean Constitution. When it says the Constitution is supreme, it means any other law now is subordinate and cannot go against the dictates of the Constitution. Then we have the issue of the horizontal application of the Constitution, which now mean that the Bill of Rights can be invoked directly or indirectly between private parties. Then when we look at the South African Constitution, as indicated earlier by my colleagues, it has brought those communitarian values like the Ubuntu, and even in the Zimbabwean Constitution, we have these key values that impact now on the freedom of contract, Such values as reasonableness, good faith, are emerging as topical and necessary considerations in the making of any contract. So this changes the texture of contract law. While this contract law remains private, but it is now no longer as autonomous as it were, because the Constitution is bringing in these things that we are talking about, the values, the peremptory norms, constitutional supremacy, and so forth. So this brings us to the end of our presentation. We used a number of references as shown on the screen there. We might not have captured all, but yeah, this is a learning process. We want to welcome you to make your contributions on how we can better improve our presentation and our knowledge, because as it is, we are just mere 2-1 level legal students who are trying to find our foot into the legal system. We thank you for watching our video, and we are waiting for your contributions and comments. Thank you very much. We also want to take this opportunity to thank our lecturer and the school for giving us this platform to just show the world what we are trying to learn, and that we are learning these things at Yebech Tepo Law School, Masvingo. Thank you.